are demonstrating that blind loyalty to Speaker Dade Phelan is more important than upholding their oath of office.
Details of the law, but folks, listen at home. Here's a quick summary of what this law is doing. It's already allowing.
This government can protect its own people, except for 36 out of every 100,000 for murders.
Year-old adults, guns that are in common use. It bans for everyone.
Because people buy hundreds of guns legally and then they sell them illegally.
Supreme Court's impactful arm control case. The Supreme Court's consideration of a section of federal law pertaining to domestic violence restraining orders and arm possession carries significant implications for arm control laws in the United States. This comes a year after the court's landmark Second Amendment opinion, authored by Justice Clarence Thomas, which expanded arms rights nationwide and emphasized that firearms regulations must align with the nation's historical traditions. The current case, known as Rahimi, seeks to clarify certain aspects of the court's 2022 decision in New York State Rifle and Pistol Association v. Bruin, particularly in the context of domestic violence. The decision in this case may reverberate through various types of arm control laws, potentially influencing laws that President Joe Biden's own son is currently charged with violating. Bruin has already played a pivotal role in lower court decisions, influencing cases involving concealed firearms, arms in places of worship, and bans on attack arms. For example, in California, a federal judge recently struck down an attack weapon ban, arguing that it infringed on the rights of law-abiding citizens who commonly use such arms for self-defense. Judge Roger Benitez contended that California's approach of disarming many citizens due to the criminal actions of a few is constitutionally unsound, echoing sentiments that date back 250 years. Ultimately, the Supreme Court's decision in the Rahimi case could shape the trajectory of arm control legislation across the country, impacting a wide range of regulations related to firearm possession and use. Protective order issued. The case before the Supreme Court centers on Zaki Rahimi, who had a heated argument with his girlfriend in December 2019, culminating in an alarming threat to take their child and a reckless discharge of an arm. Subsequently, a protective order was issued against Rahimi, finding him guilty of family violence. This order suspended his handgun license and prohibited him from possessing an arm. Rahimi's tumultuous behavior continued, involving him in a series of shootings in Texas, including one at a Whataburger in January 2021. When the police obtained a search warrant for his home, they discovered both a rifle and an arm, with Rahimi openly admitting he was under a protective order. Initially, Rahimi attempted to challenge the constitutionality of the law, but was unsuccessful. However, the landscape shifted when the Supreme Court issued its significant Second Amendment decision in Bruin, which emphasized the need for gun regulations to align with the nation's historical tradition.
To run enhanced background checks on young people under 21 trying to buy a firearm. Details of the law, but folks, listen at home. Here's a quick summary of what this law is doing. It's already allowing.
This government can protect its own people, except for 36 out of every 100,000 for murders.
Capitalizing on this ruling, the Fifth U.S. Circuit Court of Appeals sided with Rahimi, asserting that Bruin had fundamentally transformed the assessment of laws related to the Second Amendment, rendering prior precedent outdated. They highlighted that the statute in question was an extreme departure from what our forebears would have accepted in terms of gun regulation. The case poses a crucial question for the Supreme Court. To what extent can a person under a domestic violence restraining order be restricted from possessing an arm? The decision is poised to have far-reaching implications for various forms of arm control legislation, potentially influencing laws nationwide.
Year-old adults, guns that are in common use. It bans for everyone.
I want to be clear, this wasn't based on violence. This is based on threats specifically to individuals, on gangs.
We can expect in the future that more people will be carrying handguns on the streets in places like Los Angeles, Boston, and New York City.
Roughly 40 million firearms with stabilizing braces in circulation to obtain a special registration.
And yet at Uvalde and in so many other school shootings, we were not willing to protect our children.
Biden administration appeals. the Biden administration is fervently defending the law, emphasizing that the Second Amendment's right to bear arms has limits and that Congress has the authority to disarm individuals like Rahimi who are under domestic violence protective orders. Solicitor General Elizabeth Proligar argues that history, both preceding and following the founding era, supports the government's ability to disarm potentially dangerous individuals. Proligar asserts that those subject to domestic violence protective orders poses a clear threat to their intimate partners, as arms often escalate domestic violence to lethal levels, with abusers frequently using guns to intimidate and harm their victims. She emphasizes that, on average, 70 women are fatally shot by intimate partners every month, underscoring the urgency of addressing this issue. Lawyers from Everytown for Gun Safety also support the law, highlighting that access to an arm significantly increases the likelihood of a woman dying at the hands of her abuser. They point out that nearly 2/3 of domestic homicides in the U.S. in 2019 involved an arm.
June of 2021, you changed the department's asylum rules so that it could apply to individuals with significant gang violence.
Most apparent here, a defense of the Second Amendment, which this most certainly is.
Wyme says the Missouri law exposes people to greater harm by interfering with the federal government's ability to enforce firearms regulations.
Because people buy hundreds of guns legally and then they sell them illegally.
J. Matthew Wright, a federal public defender in North Texas, maintains that the Supreme Court should stand by its Bruin decision, asserting that the law is inherently unconstitutional. He contends that the federal government has failed to find any American jurisdiction during the founding generation that implemented a similar ban. Wright also challenges the findings of the civil proceeding that led to the restraining order against Rahimi, arguing that it was a one-sided process with boilerplate conclusions. He notes that while the founding generation did address domestic violence through various measures, they never resorted to a ban on arm possession. Wright maintains that the founding generation would have resisted a federal law dictating which citizens could and could not possess arms. The case raises profound questions about the balance between Second Amendment rights and safeguarding individuals from domestic violence threats. It underscores the broader implications of this decision on a range of arm control laws, making it a pivotal moment for the Supreme Court. Supreme Court debates arm control. During the oral arguments, attention will be focused on specific justices, with a keen eye on their past positions and statements regarding Second Amendment rights. Justice Brett Kavanaugh, who joined Chief Justice John Roberts in the 6-3 Bruin decision, emphasized in his separate opinion that the Second Amendment is not an absolute right. He noted that it neither serves as an inflexible constraint on regulation nor a carte blanche for unrestricted gun ownership. Kavanaugh emphasized that, with proper interpretation, the Second Amendment allows for a range of gun regulations, indicating a nuanced approach to the issue. Justice Amy Coney Barrett, in her previous role on a lower court, dissented when her colleagues rejected a Second Amendment challenge from an individual with a felony record, thereby barring him from arm possession under federal and Wisconsin law.
Are demonstrating that blind loyalty to Speaker Dade Phelan is more important than upholding their oath of office.
Might end up being a message amendment because the President of the United States will almost assuredly veto it.
I'm just inspired by the next generation. I think it's a time for a big change.
Types of disputes that would be settled by people yelling at each other, maybe engaging in a fist fight, are being settled with guns.
Barrett argued that history supports the notion that legislatures have the authority to prevent dangerous individuals from having guns, emphasizing the importance of distinguishing between individuals who pose a genuine threat. She pointed out that the law applied to all felons, regardless of the nature of their offenses, which she deemed unconstitutional in this specific case. This suggests her interest in developing a standard based on assessing the level of dangerousness associated with an individual. Given their prior opinions in Second Amendment cases, the questions and comments from Justices Barrett and Kavanaugh, along with Chief Justice Roberts, are anticipated to provide significant insights during the oral arguments, shedding light on their perspectives on this critical matter.
And no one contends otherwise. But what are the limits? Wouldn't it be nice to hear?
Requires agencies to submit a rule to Congress before the rule can take effect. After submission of a rule by the agency,
or policies as before us today to make it harder for law-abiding citizens to obtain firearms.
Conventional wisdom was we would never get any Republicans to support gun legislation, period.
Are ones where, in fact, it's most likely that they should be bringing the highest and mandatory minimum.
Supreme Court's gun law impact. The Supreme Court's upcoming decision in the Rahimi case are poised to have far-reaching implications, extending beyond the realm of domestic violence-related arm restrictions. It's expected to impact various court rulings that relied on the Bruen decision to challenge federal arm laws. One of the cases in the spotlight involves a law that prohibits firearm possession by an individual deemed an unlawful user of or addicted to any controlled substance. In a recent development, the Fifth Circuit overturned this law, drawing heavily from both Bruen and its own Rahimi rulings. This particular case involves Patrick Daniels, who was apprehended in 2022 for driving without a license plate. A search of his vehicle revealed marijuana remnants, a loaded pistol, and a loaded rifle. Daniels was subsequently indicted for firearm possession as an unlawful drug user. Hunter Biden's legal team has indicated their intent to leverage the Fifth Circuit's decision as part of their defense. Attorney Abby Lowell has pointed out the constitutional uncertainty surrounding the charges. This stance contrasts with the Biden administration's position on the federal gun law. Hunter Biden himself has publicly criticized the nature of his case. In an op-ed for USA Today, he highlighted that he's facing charges of possessing an unloaded gun for a mere 11 days, 5 years prior, charges that seem unprecedented in Delaware's history. The potential ripples of the Rahimi case on such legal battles highlight the weight and significance of the impending Supreme Court decision. That's all for this video, folks. See you next time.